And when you get them to that, when you've done all this setup work with them, it's pretty clear where you're going with this. Fish or cut bait time. What do you really want to do here? Now, then you get to use your handy dandy tool bag, which is full of your reality testing skills, right? Anybody have a favorite reality testing skill? Deborah.
Well, in Rolling Meadows,
Where they fight over plastic spoons, I'm told.
Yeah.
Go ahead.
It's pro se court, and the judges, in my personal opinion, not particularly well suited for pro se court. So
Yeah, Raj
you know,
retired.
if-
She was fabulous.
If one has parties that have sat in the courtroom for a couple of trials, then it's a very good technique there, I found. So, well, you really want to stand up in front of this judge? You can
That
kind
is
of
an
say
excellent-
both of them at the same time.
That's an excellent technique. What have you seen? What's been your experience so far? Right?
One that just happened out of Rolling Meadows, it seems that Deborah was out there, was after the mediation was finished and we didn't resolve it, a woman told me that she really didn't want to go back and see the judge. She was really glad that she settled because she didn't want to go back and see the
Yeah.
judge.
That's scary.
Sure. Have they seen it? My home state, there was a judge by the name of W. Douglas Albright. He's a Superior Court judge, and in North Carolina, if you don't like your result in your district court case, you can appeal it to the Superior Court. But you can't do any judge shopping. Those things are randomly assigned. So when Judge Albright would come into the county and cases would be assigned to him, there would be a long line of people with orders in hand to have their case remanded to the district court because nobody wanted to go in front of Maximum Doug. Nobody was interested for some reason or the other. You know, it's the same way. If you sit out there for a couple hours and you watch this judge just making all kinds of decisions that don't look good for you, it's good. It would sober me up. I think it would most people. What else? Anybody else got favorites? By the way, my favorite thing with people when I used to case manage in Rolling Meadows, if they didn't want to go to mediation, I'd be, oh, fine, no problem. Just get up there and tell the judge you don't want to go. But if they make you go, you go on the rear of the line. Very effective. Gets them right in that mediation line very quickly. What else? Somebody have one?
Yeah, and I find a lot of times people are angry or upset that they're in this situation. And what I've tried to do is, say something like, whether you deserve to be here or not, whether you should be here or not, it doesn't really matter. This is where you are, and let's try and, help you think through the best way you're going to get out of it.
I can't do anything about that,
Right.
but what I can do is I can try to help you get out of the situation. And I assume you do that to both parties. You say that to both
Yeah.
parties in a very balanced fashion. I think that's good. That's good. That's a good setup piece. It's a good piece to throw in there. Other pieces? See, I have to do this because I like to rip off what my students know. I don't think teaching should be a one-way street. I think I should get some things when I leave too. So, what else you been doing? Anything you find particularly effective, Gene?
What's it going to cost you?
What's it going to cost you? And when you say what's it going to cost you, what do you mean?
To both sides. What's it going to cost you if you settle? What's it going to cost you if you don't settle? What are you looking for?
Do you do a good deal of detailed analysis with them about what that all would be involved in that?
To the extent you can, out of Rolling Meadows, you don't have a lot of time for that. But it depends
Right.
on what their response is, how far you want to take it.
Cost, just the sheer cost of proceeding in terms of the money, the filing fees, attorney's fees, time, present value of money versus future value of money. A lot of different ways you can work the cost angle. And again, I think the setup of that is very critical because what you don't want to do is say, well, now that we know what you are, let's talk about how much you charge. You want to set that up as this is something we're doing for you. We want you to think carefully about this in your own benefit, to your own benefit, to think about the cost. We're not asking you to sell your principles. We're not asking you to prostitute yourself here, but we're asking you to think carefully about where's the stopping point? Where's the point at which it's really not worth it to you to do this? And how do you evaluate that?
And sometimes I'll talk to people about, have you ever been involved in litigation before and know what that means as far as your time commitment and intrusion into your life and emotional ups and downs involved in that. So it's not just the out-of-pocket costs, which of course can be considerable, but there's other costs. And
Sure.
people who haven't done it themselves, very often you will find them will say, well, yeah, I know so-and-so and for 8 years.
Sure. I just settled the case this week. Well, it's not signed yet. We hope it's settled. In which a lot of it turned on the fact that the complainant basically been living this case now for a year and was looking at living it 2 or 3 more years. And you add the added twist that he's terminally ill, and you get a guy who doesn't really want to do this. It's just not worth it to him. It's something for people to think about. What will the non-monetary costs be to me, my family, my employer, other people who are gonna be kind of tied up in this with me? What else? Mark?
I find that sometimes I have to remind people, not by telling them the questions, that what they are sure is the truth is not something the judge is going to know is the truth, or the IDHR investigator is going to know is the truth. Because they're going to have to go through some process by which it convince them.
How do you do that? Do you ask them, what do you say to them when you do that?
Well, I say, okay, assuming that what you're saying is all true, every word of it. How would someone who wasn't there when the accident happened?
Okay.
How is someone going to know that?
Good question. Good question.
In the juvenile cases, I think sometimes flip side I find is helpful with the juveniles. How would you feel, especially if they're really denying that they've done anything or saying they didn't do anything, it would be kind of like, well, how would you feel if, somebody had hurt your property and, whatever the situation is. And sometimes I find that I get some information from the kids that way.
Sure. You can say, how would you feel if this happened to you? Or
You're right.
I think you can even say things like, do you think you believe the other person?
Mm-hmm.
What kinds of things would convince you? What kinds of things you think would cause you to lose credibility or cause that person to lose credibility if they would tell you that? It's a way of helping them evaluate their own position. Yes?
At IDHR, one thing I've started to ask is, actually to both parties, what will it be like to have, if we don't come to an agreement here, to have an investigator mucking around either in your workplace or with your work buddies, and what effect will that have on your workplace, your friends, and that's something usually they haven't thought about.
Okay. So having the investigator in your workplace, having them look around in your files, talk to your employees.
Raise their awareness of these
What's-
issues.
Sure. I think that can be very effective, particularly for employers who may not have thought about the possibility that continuing to litigate might get people out there smoking around. Good. You guys got some good stuff. What else?
I have a question.
Mhm.
I like the flip side a lot,
Okay.
but sometimes I find that if it's not a particularly harsh one, that it's sometimes more effective to do it crosstalk, because the other side then sees that the other person can really see beyond their own position, and
That's interesting.
I've done it both ways. Sometimes in projects, sometimes in caucus, and sometimes now, depending on the situation, I could kind of detect if it could be effective in crosstalk. And when it is, it's really effective because I think it loosens up both sides.
Well, now that's actually something I had never thought about as a potential benefit to doing the flip side in the crosstalk. So the plus side of the flip side in the crosstalk would be that it might almost be a model. One party models for the other that they are actually able to look at the other person's view of things, or look at it from the other person's perspective.
Sometimes it comes up kind of naturally, let's say a juvenile case and somebody has kids, example, you know, you can talk about their own experiences with their own kids, or how they've handled other situations, or how, you know, it's sometimes it comes up pretty naturally that you could just take it the next step, and that's when I think it's more safe in a crosstalk. But if that didn't come up so naturally, I'm not sure I would do it in crosstalk. I would just take it in caucus.
Okay. Well, I may have to try that a few times because my tendency has been to keep the flip side in the caucus for the simple reason that one of the reactions that you run the risk of getting is, well, I wouldn't do what that SOB did, you know, kind of something. I know why I wouldn't do that. Just use that as an opportunity to run on the ground for what they did. But you're saying that your experience has been to the contrary. What they sometimes do is proceed to see it from or look at it from the other person's view.
Right, but it takes a judgment call. I mean, it's hostile, and there are times that I definitely wouldn't do it. But there are times
Okay.
where I think if the conversation's leading that way, I could do it then.
That's good. I think that's a good way of looking at it, contextual. So that the judge will call in the context of the parties and sort of reading on it. Good. Other things that people have been using to reality test that you find particularly effective?
Well, daily, I find the issue of control. I mean, is this reality testing? Is this a need and interest? You know, what poll you want to put it in. But in terms of this is, you know, if they don't seem to be getting anywhere, you know, this is where do you have the opportunity if you go back into the courtroom? What happens to your ability to determine your own fate? And you know, some people, you know, are just kind of passive, and that's what they want. They want somebody to determine their fate. But if they seem like fairly active people, fairly decisive people, particularly people who the wrong is that somebody made a decision for them or took away some piece of control, that can be important.
Okay. Good. I used to do that as a setup piece when I did short models, which I hate when I did them. That I would say to the parties early on in the mediation, you know, this is your opportunity to keep control of the outcome. You go back in the court, the person with the black robe on is going to make a decision for you. And as far as I know, you can't both win. Or maybe sometimes I would ask, can you both win? And they might say, obviously no. Well, this is the opportunity for you to keep control of your agreement, for you to keep control of what's going to happen to you when you walk out here today. As a way of saying that. Letting them know that that's an important piece of it. Yes?
There's another technique, I don't know if you call it reality testing or not. Sometimes after a fairly vigorous exchange in the crosstalk, I might not do anything. I might just sit and not say anything for a while, let them think about what they just heard. And then, you know, see what happens after that.
Yeah, I think it could be. I think it could just be a silent strategy, but it could be reality testing in the sense of they may be looking to you, the mediator, to respond. And they may be expecting that you will respond. You don't. So, if nothing else, Gene, I think it keeps them guessing.
Right.
About what's in your mind, and why you have so little to say. And it could be you might be sitting there thinking to yourself, "Well, that was stupid." They don't know that, right? So it keeps them guessing. I mean, I have to say, sometimes when I'm speechless, it's because I'm speechless. Because I'm like, I can't believe this idiot said that. Now what do I say? You know, who knows? So you just kind of sit there for a minute. Okay, so here's the thing I think in terms of reality testing skills. I've never done a mediation which I did not do the BATNA. If you do a mediation and you didn't do BATNA, you didn't do it right. Go back and do it again because you want to ask the BATNA question. It's so simple. What are you going to do if you don't reach an agreement today? Now, it could be that you won't get a thing that you didn't already have. Right? They're going to rehearse for you. This is where I'm going. This is what I'm going to do. But sometimes other things come up. Positive things sometimes not. But other things come up. That question should always be asked. Right? I also think you should always do the WATNA. What's the worst thing could happen to you? if you don't reach an agreement. And also the Malata, the most likely thing that could happen to you if you don't reach an agreement. Because people will tend to focus on those two poles. One will generally focus on the worst thing that can happen. The other one will generally focus on the best. And they're both in denial to some degree. When you ask them directly, what's the more likely? What's the range? What's the most likely range? You usually get closer to reality. So just that simple question, what's the range, can oftentimes bring things a lot closer together. So you always do that. You always do a cost-benefit analysis, and we've talked some about that. You always want to reality test just the sheer cost of what they're going to try to do. Now, this has a practical effect because for many, many people, particularly business people, that's where it's all at. It really is. Bottom line is, what are the comparative costs to pressing litigation, to settling with these people? And sometimes people take a broad view of that. That's in part what's behind the so-called floodgate defense that you see respondents take, where they'll say, well, I can't settle it. I literally cannot settle this case because if I did, it would mean that hundreds of people would file. And the aggregate cost of defending all those little suits and settling all those little suits would be greater than the cost of pressing this one all the way to the line and winning. So that's a cost-benefit analysis too, and that's the way they're calculating their costs and their benefits. Now, I doubt that whole floodgate thing. I'm very skeptical of that if you settle with somebody for a couple $1,000s for a sex discrimination suit, for example, that all of your employees are then going to go run out and file sex discrimination suits. I kind of doubt it. One or two might, or three or four might. But you know what? You could settle all those for $2,000 too and still be a whole lot ahead of what it would cost you to litigate one. So I'm real skeptical of that defense, and I will sometimes ask them, what makes you believe that's going to happen? Do you know of any company where that's ever happened, where a high percentage of their employees filed suits based on settling one suit? Because I don't believe it. I won't see it. Anybody here know where it happened? I want to see it. So a careful cost-benefit analysis, cost of legal fees. There are a lot of costs that people don't think about that you want to help them factor in. How much downtime is there going to be for your employees to be at trial, to be in depositions, to be interviewed, to send in written positions, right? How much lost productivity will there be to the company if that happens? What are the potential costs? Somebody raised an issue over here, having people poke around your business. Might they discover other violations? Might they raise the consciousness of your employees as to what constitutes a violation, and thus get you some filings just based on that? Right? So there's a ton of cost things that you want to carefully ask them to consider, and all the stuff that goes with it. Travel expenses, experts, whatever you think reasonably might be involved. And sometimes I'll get that information from them. I'll say, tell me what you're going to do to prove your case. Walk me through it step by step. Tell me exactly what you're going to do. Now, this is a little difficult when you have pro se parties, because most of the time pro se parties don't have a clue about that. They don't know what's coming. Fine, I turn that around on. If I have pro se parties, I'll say, how are you going to do this? Tell me, step by step, how does this work? You know how to conduct a trial? You know who talks when, who says what? Did you watch? Because some of the judges will help you do it. They will tell you, now, you, tell your story. Now you, ask questions. How about you tell your story? Now you ask questions. Some of the judges won't do that. They'll just say, what do you got? And if you don't do it right, what happens? You don't get it. They're not going to help you. So they need to think about that. How will they do it? Will they have a judge who will help them? Will they have to do it on their own? Will they have, what kind of proof will they have to have? You know, you usually have witnesses, right? And in pro se cases, witnesses are usually who? Family members, friends. So you want to talk to them a little bit about their witnesses and their witnesses. Kind of walk them through that. Evidence like photographs. How many of you have had evidence, really bad evidence, at courts? What you have?
I had a lawyer who came to trial with an affidavit instead of a witness.
Yeah, okay.
He was.
That's actually, in the world of pro se, that's pretty agreeable. I've had some really interesting evidence. Anybody else have anything good?
Pictures.
Pictures?
Floor tiles?
Floor tiles? This is getting better. What else? How about dead rats? We've had dead rats. Dog turds and piles of leaves. We've had that. Can you imagine that? Somebody taking a big old bag full of leaves and dog poop and dumping it on the table in front of you and saying, here's the evidence? Had a guy who had shoes made once. He had part of his foot amputated and the shoes did not fit well. So this guy's up in front of the judge, shoving this shoe up in his face, saying, see, look right down in there. And the judge is, doing this number. I mean, you get the strangest evidence in pro se cases. Dale Kimmerer used to be out at Rolling Meadows, used to tell the one about the toupee. Guy opens up this bag and he dumps this thing on the table. And Dale's like, he thought it was a roadkill. He thought it was a roadkill. And he looked at it, he said, what is that? The guy said, well, it's a toupee. It doesn't fit properly, So you get all this strange evidence. That's the kind of thing people really think that they're going to get up there in front of a judge, and this is going to be conclusive, persuasive. So your job as the mediator is to kind of gently, nicely, help them to consider what kind of evidence they might need and might be convincing for the judge. I had two women once in a sex case, harassment case at IDHR, and they were represented. And I asked one of them, I said, so how do judges make decisions? She thought for a minute and she said, well, they look deeply into your eyes and they just can tell who's telling the truth. Right? Now, I believe there's a credibility component in court cases. I mean, I think there are places where people in any trial gain and lose credibility in the eyes of either the judge or the jury or whoever's finding fact on them. I think that's true. But, absent a fact pattern and absent any evidence, it's going to be a little tough. Whether they're looking deep in your eyes or not, it's going to be a little tough. And you want them to think about that. Right? So it's walking them through all this stuff, the cost-benefit analysis, how you're going to prove it, what's required, how you're going to conduct your trial. Do you know that? If they're represented, this is even better because you can then use your attorneys. And this is what I mean on the sheet when I talk about using the attorney. Use your attorneys, folks. They are a resource for you in mediation. Ask your attorneys, what do you have to show to beat the other side? What do they have to show to beat you? Now, what do you get when you ask that question? You get a mini lesson in the law, right? If you didn't know it, you will when they get done telling you, right? You get some idea of what? What they think the strengths of their case are, and what they think the strengths of the other side's case is, and what they think the weaknesses of their case is, and vice versa. And by the way, if you ask one side in caucus this question, what are the strengths of the other side's case? That's the same thing as asking what? What are the weaknesses of mine or yours? Now, if you would ask them directly, what are the weaknesses of your case, what would you get? You'd get some song and dance, some dog and pony show, and you wouldn't get the real thing. But if you ask them the strengths of the other side's case, you will probably get it, undiluted. Which is very interesting but true. So you can get them to tell you what they have to prove, how they're going to do that, what they think their chances are, what they think the hard things for them to do will be, what they think the hard things for the other side to do will be. And the hard things for the other side are what for you? Ammunition. you can take that and you can use that to formulate your reality testing questions on the other side. I generate a lot of my reality testing questions for one side out of what I glean from what the other side tells me. So that's what I mean by using your attorneys. I will use attorneys sometimes by playing a role. Like I had this case once where it was a, let's see, what was the deal on this thing? It was a discrimination case based on race, that was it. And it was a complainant who had worked at this place about 15, 18 years. So this was not your average drop in, file them, settle them for $500 kind of case. This is a person who'd been around for about 15 years. And she alleged discrimination based on race because she had a supervisor who was of another race who seemed to have a record, pretty good long track record of somehow assigning all the people of her race to another department and sort of menial kinds of tasks and a lot of disparity in the way things operated in the office. So it was on the face of it a better than average kind of case. So the way I handled that, I asked they were both represented. I said to the respondent's attorney, I said, so let's say that I were this complainant and I came to you and I told you that I wanted you to represent me as a complainant. What would you do? How would you proceed? And he said, well, I would tell you that these things were strong about your case. These are things you had in your favor. I'd tell you that these are things you had problems with. I said, what do you mean? You have a problem with this. This was in a role play. And what we did was we role played this out, and he beat me up as his client. He said, yeah, you got this case, you got these things going for you, but this is the problem. This is what you're gonna have to overcome. This is what you don't have evidence for. This is what isn't going to work. This is what they're going to say. Now, what was the benefit of that?
Well, you could go to her and kind of ask her some of the same questions, probe how she thought she was going to handle those.
Now, let's say I did that in a crosstalk. What would the benefit be? And which is where I did it, by the way.
Do each other's position.
Yeah. The complainant got to see what?
What she was going to be facing.
The weaknesses that her own attorney probably had not confronted her with. This is what you're up against. Yeah, you got these things going for you, but these are the hurdles you've got to jump. This is what you're really going to have to overcome, or you're not going to. Then I turn around and I role play with the other side, and I say, okay, you, complainant's attorney. Suppose I came to you as the respondent, and I said, I'm being sued. This